Thank you, Mr. Chairman. 6 quick yes or no questions. Will you commit to no interference with the scope of the special counsel's investigation?
I will. The scope of the special counsel's investigation is set by his charter and by the regulations, and I will ensure that those are maintained.
Will you commit to providing Mr. Mueller with the resources, funds, and time needed to complete his investigation?
Yes.
Will you commit to ensuring that Special Counsel Mueller is not terminated without good cause, consistent with department regulations?
Absolutely.
If Special Counsel Mueller makes any request, for instance, about the scope of his investigation or resources for his investigation, will you commit to notifying Congress if you deny that request?
I think the regulations require notification of Congress if there's a disagreement.
Thank you. And I have 2 questions from the chairman of the House Judiciary Committee. Will you commit to making any report Mueller produces at the conclusion of his investigation available to Congress and to the public?
As I said in my statement, I am going to make as much information available as I can, consistent with the rules and regulations that are part of the special counsel regulations.
Will you commit to making any report on the obstruction of justice public?
That's the same answer.
Thank you. In your June 2018 memo about obstruction of justice to the Mueller investigation, you repeatedly referred to Mueller's, quote, sweeping and all-encompassing interpretation of Section 1512, which is a statute on obstruction. How do you know what Mueller's interpretation of 1512 is?
Well, as I said, I was speculating. I freely said at the beginning, I was writing in the dark, and we're all in the dark. Every lawyer, every talking head, everyone who thinks about or talks about it doesn't have the facts.
So I spent my Saturday reading that memorandum.
Yeah.
So are you saying this is all your speculation? It's a big memo.
Well, it was informed to the extent that I thought that was one of the theories being considered. And I don't know how seriously, whether it was being considered or how seriously it was being considered. But as a shorthand way in the memo of referring to what I was speculating might be the theory, I referred to it as Mueller's theory rather than go in every time I mention it, say, well, this is speculative.
Do you know what Mueller's interpretation of 1512 is?
No, I don't know what Mueller's interpretation. Okay. But and just one point, Senator, I think you said in your opening statement, I said he was grossly irresponsible. I think I said if something happens, it would be grossly irresponsible. I was not calling Mueller grossly irresponsible.
I understand. Thank you. I appreciate that. Has anyone given you non-public information about Mueller's investigation? I don't
recall getting any confidential information about the investigation.
Your 2018 in it, you stated, and I quote, "The framers' plan contemplates that the president's law enforcement powers extend to all matters, including those in which he had a personal stake," end quote. Please explain what you base this conclusion on.
Yes. Here's the Department of Justice right here. And within the Department of Justice, enforcement decisions are being made. The president's over here. And I think of it as there are 2 categories of potential communications. One would be on a case that the president wants to communicate about that he has no personal interest in, no political interest in. Let's say the president's concerned about Chinese stealing trade secrets and say, I want you to go after this company that's being, that may be stealing trade secrets. That's perfectly appropriate for him to do, to communicate that. But whether it's bona fide or not, the Department of Justice's obligation and the Attorney General's obligation is not to take any action unless the Department of Justice and the Attorney General, reach their own independent conclusion that it is justified under the law, and regardless of the instruction. And that's my quote that everyone is saying I'm sicking the, it's okay for the president to direct things. All I said was, it's not per se improper for the president to call on the department for doing something, especially if he has no personal or political interest in it. The other category of cases, and let's pick an easy bad example, would be if a member of the president's family or a business associate or something was under investigation and he tries to intervene. He's the chief law enforcement officer, and you could say, well, he has the power, but that would be a breach of his obligation under the Constitution to faithfully execute the laws. So, in my opinion, if a president attempts to intervene in a matter that he has a stake in to protect himself, that should first be looked at as a breach of his constitutional duties. Whether it also violates a statute, depending on what statute comes into play and what all the facts are.
Including the emollients clause of the Constitution.
Well, I think there's a dispute as to what the emoluments clause relates to. I have not personally researched the emoluments clause. I can't even tell you what it says at this point. Off the top of my head, I would have said, well, emoluments are essentially a stipend attached to some office, but I don't know if that's correct or not. But I'm sure I think it's being litigated right now.
I don't know either, so I'm going to try and find out. We'll come back another day and maybe discuss it. Your memo stated a fatal flaw in Mueller's interpretation of 1512C2 is that while defining obstruction solely as acting corruptly, Mueller offers no definition of what corruptly means. My understanding is that there's nothing in the public record that sheds light on his definition of obstruction. Do you know what his definition is?
I don't know what his definition is. I read a book where people were asking whether someone was, I don't know if it was accurate, but whether the president was acting with corrupt intent. And what I say in my memo is actually people don't understand what the word corruptly means in that statute. It's an adverb, and it's not meant to mean with the state of mind. It's actually meant the way in which the influence or obstruction is committed. That's its adverbial function in the statute. And what it means is, using it in the 19th century sense, it meant to influence it in a way that changes something that's good and fit to something that's bad and unfit, namely the corruption of evidence or the corruption of a decision maker. That's what the word corruptly means, because once you dissociate it from that, it really means very hard to discern what it means. It means bad. What does bad mean?
Let me go on because my time is so limited. You argue that and I quote, the Constitution's plenary grant of those powers to the president also extends to the unitary character of the executive branch itself. Specifically, you argue, and this is a quote, while Mueller's immediate target is the president's exercise of his discretionary powers, his obstruction theory reaches all exercises of prosecutorial discretion by the president's subordinates, from the attorney general down to the most junior line prosecutor, end quote. So if the president orders the attorney general to halt a criminal investigation for personal reasons, would that be prohibited under your theory?
Prohibited by what?
By
the Constitution.
The Constitution.
I think it would be a breach of the president's duties to faithfully execute the law. It would be an abuse of power. Whether it would violate a statute depends on all the facts and what statute someone would cite me to. But I certainly think it would be an abuse of his power. And let me just say that the position—
Would that be the same thing if an attorney general fired U.S. attorneys for political reasons?
No, because U.S. attorneys are political appointments.
According to news reports, President Trump interviewed you and asked you to be part of the legal team defending him in the Mueller investigation twice. First in the spring of 17, when the investigation was just beginning, and again earlier this year. Is that correct?
No. I had one conversation with him that related to his private representation. I can describe that for you. That was in June of 2017. That's the only time I met him before I talked to him about the job of Attorney General, which obviously is not the same as representing him.
Have you discussed the Mueller investigation with the President or anyone else in the White House?
I discussed the Mueller investigation, but not in any particular substance. I can go through my conversations with you if you want.
Well, not at this time, but I may come back to you
Okay.
and ask you about that. I don't want to take any more time. Thank you, Mr. Chairman.
Senator Brett.
Before I ask my first question, and I don't want you to respond to this, I just want you to know what my interest is in the transparency of the Mueller report. When we spend I don't know whether it's $25 million or $35 million, the taxpayers, that's billions of dollars, the taxpayers ought to know what their money was spent for. So if you've got some reservations about some part of it not being public, I hope that that's related to traditional things that of the public's business that shouldn't be public, like national security as an example, not being made public. But beyond that, the only way I know for the taxpayers to hold anybody that spends the taxpayers' money responsibly is through transparency, because that brings accountability. My first question, as you would expect from our conversation in my office, 86, Reagan signed the False Claims Act. I worked hard to get that passed, especially provisions empowering whistleblowers to help government identify fraud. More than a decade ago, you said the key TAM provisions in the False Claims Act were, your words, an abomination and were unconstitutional. You said you, in your words, wanted to attack the law, but the Supreme Court upheld the law's constitutionality. Prosecutors from both sides of the aisle have praised the law as the most effective tool government has to detect and actually recover public money lost to fraud. Since 1986, the law that was passed in 1986 brought in $56 billion into the federal treasury. Most of that's because patriotic whistleblowers found the fraud and brought the case to the attention of the government. Is the False Claims Act unconstitutional?
No, Senator. It's been upheld by the Supreme Court.
Do you consider the False Claims Act to be an abomination?
No, I don't.
Does the False Claims Act benefit the taxpayer, specifically its provisions to empower and protect whistleblowers?
Yes, Senator.
If confirmed, do you commit to not take any action to undermine the False Claims Act? Further, if confirmed, will you continue current Justice Department staff and funding levels to properly support and prosecute False Claims Act cases?
Yes, I will diligently enforce the False Claims Act.
Now, with all those positive answers, you'd think I'd be done, wouldn't you, with that? But let me go on. Yeah. Just to show you that there is some forces out there that I'm suspicious about within the Department of Justice, we have a new Department of Justice guidance document out last year known as the Granston Memo. Provides a long list of reasons that the department can use to dismiss False Claims Act cases, some of them pretty darn vague, such as preserving these are their words, preserving government resources. Just think of all the mischief those three words can bring. Of course, the government can dismiss obviously meritless cases. I don't argue with that. But even when the department declines to participate in False Claims Act cases, the taxpayer can in many cases still recover financially. So it's important to allow whistleblowers to pursue cases even when the department isn't able to be involved. Under what circumstances can or should the Justice Department move to dismiss false claims cases?
Senator, I haven't reviewed that memorandum, so I'm not familiar with the thinking of the people in this. I think it's the Civil Division that did that, but if I'm confirmed, I will review it, and I would be glad to come and sit down with you and discuss it, and if there are areas you're concerned about, I'd be glad to work with you on that.
Unless you find that my presumption is wrong, that there's reasons to be suspicious, I hope you'll take into consideration my feeling about how, in various suspicious ways, people that are faceless bureaucrats can undermine this effort. In circumstances where the government doesn't intervene in false claims cases, if confirmed, will you commit to ensuring the department doesn't unnecessarily dismiss false act cases?
Yes, Senator, I will enforce the law in good faith.
Okay. Now, got an act that the Justice Department just took, and I can't obviously expect you to respond specifically to their act, but I use it as an example of their uncooperation with the Department of Congressional Oversight. This uncooperative behavior needs to change. On December the 10th last year, the department confirmed a briefing for your staff regarding asset forfeiture fund, and to do that last week, January the 8th. On January the 7th, Department of Justice Office of Legal or Legislative Affairs informed our staff that they will no longer provide the briefing because they consider the matter closed as a result of the change in chairmanship, and because you released a public memo, because I released a public memo on the Marshal Service study or investigation. It's important to gain your commitment on how you would handle this as an example. Let me explain how ridiculous it is to get somebody in this administration saying that they don't have to answer if you aren't chairman of a committee. We went through this in January, the first month this president was in office, when he said, or he put out a memo, we aren't going to answer any oversight except for chairman of committees. So you're going to write off 500 members of Congress not doing oversight. So we told them all about this and the constitutional cases on this. We got them up. They wrote a memo again 2 months later that said that they were going to respond to all this stuff. Now you got people in the bowels of the bureaucracy that are still saying, if you aren't a chairman, you ain't going to get an answer to anything. How ridiculous. It's our constitutional responsibility. So then I laid out, I'll give you an example. I sent the Justice Department a classified letter regarding information acquired from the Justice Department Inspector General report on the Clinton investigation. The department ought to answer for what the Inspector General has found, but I haven't heard a peep, not a peep, on that yet. On December the 10th, the Justice Department, well, I'm repeating here. So the question is, do you understand that if you're confirmed, you have an obligation to ensure the Justice Department, and particularly the FBI is a problem, respond to congressional inquiries, and to do it in a timely manner?
Absolutely, Senator.
You understand that this obligation applies regardless of whether you're a member of Congress or a committee chairman?
Yes, Senator. You and Senator Leahy, I think, are the only members of the committee now who were here 27 years ago when I was first confirmed. But I think you will recall that we were able to establish very cooperative and productive relationships with all the members and try to respond to their questions and deal with their concerns and work with them on projects they're interested in. And that will be the same approach that I will bring to the job if you confirm me.
Okay. Then let me be specific on my last question on oversight. You remember when you were in my office, I gave you, as I gave Attorney General Sessions, as I gave Holder, a long list of things that the department has not answered. And one of these was an October 17, 2018 letter. And I'd like to have your response to answering that letter and respond to all outstanding and future oversight requests in a timely manner. And then, remember, I said, all you cabinet people come up here to tell us yes when we ask you if you're going to answer our stuff. I said, maybe you better say maybe. So if you want to say maybe now and be really honest, say maybe. Otherwise, I hope you'll answer that October 17th letter once we get you voted into office.
Yes, Senator.
Throughout your career, you've expressed concern with congressional attempts to enact criminal justice reform and at times advocated for stricter mandatory minimum sentences. In '92, under your direction, DOJ published a report entitled The Case for More Incarceration. This report declared that the problem with our criminal justice system was that we were incarcerating too few criminals. More recently, in 2015, you signed a letter opposing the Sentencing Reform and Corrections Act of 2015. This letter states quite clearly your opposition to sentencing reform, particularly the lessening of mandatory minimum sentences, any sort of retroactivity. The First Step Act was signed by President Trump. As Attorney General, it'll be your job to implement the legislation. Even though you've opposed criminal justice reform in the past, will you commit to fully implementing the First Step Act?
Yes, Senator. But in 1992, when I was Attorney General, the violent crime rates were the highest in American history. The sentences were extremely short. Typically, in many states, the time served for rape was 3 years. For murder, time served 5 to 7 years. It was the system had broken down, and I think through a series of administrations, Reagan, Bush, and Clinton, the laws were changed, and we targeted chronic violent offenders, especially those using guns. And I think the reason the crime rate is much lower today is because of those policies. So I don't think comparing the policies that were in effect in 1992 to the situation now is really fair. And I think, and I've said, that right now we have greater regularity in sentencing. There's broader recognition that chronic violent offenders should be incarcerated for significant periods of time to get them off the streets. And I think the time was right to take stock and make changes to our penal system based on current experience. So I have no problem with the approach of reforming the sentencing structure. And I will faithfully enforce that law.
Don't take it personal if I raise my voice to you. I'm not mad at you.
If I were you, I'd answer his letters just as sort of a tip that may help you through your job if you get it. I'll take the time away from my second round. I'm very curious about the conversations you had about personal representation being Attorney General. You mentioned it, Senator Feinstein. Can you kind of give us a summary of what you were talking about?
Yeah, so in June of 2017, middle of June, Ambassador David Friedman, who's the U.S. ambassador to Israel, who I didn't know. I knew that he was a top-tier lawyer in New York and apparently a friend of the president's. He reached out to me and we talked one evening, and he said that my understanding was he was interested in finding lawyers that could augment the defense team. And failing that, he wanted to identify Washington lawyers who had broad experience that whose perspective might be useful to the president's. And he asked me a number of questions like, what have you said about the president publicly? Do you have any conflicts and so forth? And I told him that I didn't think I could take this on, that I had just taken on a big corporate client that was very important to me and I expected a lot of work. And I said at my point in life, I really didn't want to take on this burden and that I actually preferred the freedom to not have any representation of an individual, but just say what I thought about anything without having to worry about that. And I said that my wife and I were sort of looking forward to a bit of respite, and I didn't want to stick my head into that meat grinder. He asked me if I would nonetheless meet just briefly go over the next day to meet with the president. And I said, sure, I'll go and meet with the president. And he brought me over and was squeezing me in. It looked to me like it was before the morning staff meeting because people were grouping by the door to get in, and I went in. And he was there, the ambassador was there, sat through the meeting. It was a very brief meeting where essentially the president wanted to know, he said, oh, you know Bob Mueller. How well do you know Bob Mueller? And I told him how well I knew Bob Mueller and how, the Barrs and Muellers were good friends and would be good friends when this is all over and so forth. And he was interested in that, wanted to know, what I thought about, Mueller's integrity and so forth and so on. And I said, Bob is a straight shooter and should be dealt with as such. And he said something to the effect like, so are you envisioning some role here? And I said, actually, Mr. President, right now I couldn't do it. My personal and my professional obligations are such that I'm unable to do it. So he asked me for my phone number. I gave it to him, and I never heard from him again until.
Well, I tried that once. So you did better.
Well, I didn't hear from him until later, but about something different, which was the Attorney General position.
Thank you, Mr. Barr. Good to see you again. As you mentioned, Senator Grassley and I were here at your hearing a number of years ago. Let me go back even before that. 46 years ago, I was not in the Senate. I was state's attorney in Vermont, and I watched with a great deal of interest the Elliot Richardson hearings. He'd been nominated to be Attorney General in the midst of Watergate. He made several commitments to the committee, including appointing a special prosecutor, and he promised to protect his independence. And I, as one who had total independence as an elected prosecutor in Vermont, I thought how important it was to have that same independence at the national level. And Mr. Richardson said it was necessary to create the maximum possible degree of public confidence in the integrity of the process. I've never forgotten that. But I think the integrity of our institutions is just as much at risk today. President Trump has made it clear he views the Justice Department as an extension of his political power. He's called on it to target his opponents. He obsesses over the Russian investigation, which looms over his presidency, may define it. He attacks the special counsel almost daily. He fired both the previous FBI director and attorney general for not handling the investigation as he pleased. That tells me the rule of law can no longer be taken for granted. So if confirmed, the president's going to expect you to do his bidding. I can almost guarantee you he'll cross the line at some point. That's why the commitments you make here today, just like those I watched Elliot Richardson make years ago, matter greatly. So will you commit, if confirmed, to both seeking and following the advice of the department's career ethics officials on whether you must recuse from the special counsel's investigation?
I will seek the advice of the career ethics personnel, but under the regulations, I make the decision as the head of the agency as to my own recusal. So I certainly would consult with them, and at the end of the day, I would make a decision in good faith based on the laws and the facts that are evident at that time.
Same thing if you're talking about a conflict of interest?
Well, no, some conflicts, as you know, are mandatory.
I'm thinking what Attorney General Sessions, and when asked a similar question, he said he'll seek and follow the advice of the Department of Justice's designated ethics officials. So let me ask you, maybe in a different way. I know you promised to not interfere with the special counsel. Are there any circumstances that would cause you to terminate the investigation or any component of it, or significantly restrict its funding?
Under the regulations, Bob Mueller could only be terminated for good cause, and frankly, it's unimaginable to me that Bob would ever do anything that gave rise to good cause. But in theory, if something happened that was good cause, for me, it would actually take more than that. It'd have to be pretty grave, and the public interest would essentially have to compel it, because I believe right now the overarching public interest is to allow him to finish.
I would agree with that, but I also think over the past 18 months you rather harshly prejudged the investigation in some of your writings.
Well, I don't see that at all, Senator. You know, when you strip away a lot of the rhetoric, the two things that have been thrown up as me sort of being antagonistic to the investigation are two things. One, a very mild comment I made that, gee, I wish the team had been more balanced. I wasn't criticizing Mueller. I believe that prosecutors, and I think you would agree, they can handle the case professionally, whatever their politics are. You know, a good prosecutor can leave their politics at the door and go in and do the job. And I think that's what Justice Department prosecutors do in general.
But you also are very critical of the Russian probe. And, I mean, I can't think of anything that would, in your memo, for example, that would jump out more for this president because of his commitment to it. And I ask that because some have said, on both sides, that it looked like a job application. And so that's what I want you to refer to.
Well, that's ludicrous. If I wanted the job and was going after the job, there are many more direct ways of me bringing myself to the president's attention than writing an 18-page legal memorandum, or sending it to the Department of Justice and routing it to other.
But also publicly criticize the Russian probe. I mean,
how have I criticized the Russian probe?
You don't have any criticism of the Russian probe?
Not at all. I believe the Russians interfered or attempted to interfere with the election, and I think we have to get to the bottom of it.
So you would be in favor of releasing the investigative report when it's completed?
As I've said, I'm in favor of as much transparency as there can be, consistent with the rules and the law.
Do you see a case where the president could claim executive privilege and say that parts of the report could not be released?
Well, I don't have a clue as to what would be in the report. The report could end up being, not very big. I don't know what's going to be in the report. In theory, if there was executive privilege material to which an executive privilege claim could be made, it might, someone might raise a claim of executive privilege.
That'd be pretty difficult following U.S. versus Nixon, when the Supreme Court unanimously rejected President Nixon's claims of executive privilege over the Watergate tapes. But I ask it because the president's attorney, Mr. Giuliani, said the president should be able to correct the Mueller report before any public release. So in other words, he could take this investigative report, put his own spin on it, and correct it before it's released. Do you commit that would not happen if you were Attorney General?
That will not happen.
Thank you. You had, when you're AG, I remember this well because I was here in the Senate at the time, you encouraged President George H.W. Bush to pardon all 6 individuals who were targeted in Iran-Contra. The independent prosecutor investigating the matter labeled that a cover-up. Now, you and I talked about this in my office, and I appreciate you coming by. I found the conversation the two of us had be well worthwhile. Do you believe a president could lawfully issue a pardon in exchange for the recipient's promise to not incriminate him?
No, that would be a crime.
Thank you. In 1990, you argued that Congress appropriation power is not an independent source of congressional power to control the allocation of government resources. There are only 3 committees in the Senate that have a vice chairman. Appropriations is one of them. Obviously, as vice chairman, I kind of looked at that. You claim that if a president finds no appropriated funds within a given category, he may use funds from another category, as long as both categories are in his constitutional purview. Now, this says Vice Chairman Appropriations Committee. Don't be surprised I disagree. Congress's power of the purse, Article 1, Section 9, I believe constitutes one of the most fundamental and foundational checks and balances on the executive branch. So do you believe the president can ignore Congress appropriations allocations, conditions, and restrictions in law? Just ignore them and take the money and
Not as a general proposition, but that was a
general proposition.
I actually thought that was a good law review article. I gave it as a speech, and it was really a thought piece. And what I was really saying was, and I say right up front, that the more I thought about the appropriations power, the more confused I got. And I was just laying out a potential template, which is this. People frequently say, you know, the power to, you know, spend money on this division or this missile system is part of the power of the purse. And what I was actually saying was, you know, actually what the power being exercised there is the substantive power that Congress has to raise armies. And it's not, it doesn't come from the power of
specific appropriations on agriculture or on defense. I mean, for example, could a president just build a wall along our southern border because he wanted to and just take the money, whether appropriate or not? What about eminent domain?
What about eminent domain?
Well, if you're going to build a wall, you got to take a whole lot of land away from landowners in Texas and elsewhere.
Well, you know, you'd have to show me what statute is being invoked and also what appropriations is being used. I can't answer that in the abstract.
So you're saying the president, though, can have the power to go into money even if the Congress is appropriated for a different purpose?
No, I didn't say that. But some
You mean that?
I don't mean that. I'm saying that you know, there are monies that the president may have power to shift because of statutory authority.
But that would have been because Congress gave him that authority.
Right.
Not because he has it automatically.
I'm not taking that position. As I said, my law review, it was published as a law review article, and it was a thought piece exploring what limits there might be to the appropriations power and where Congress's power comes from in certain areas.
Thank you. Thank you, Mr. Chairman.
Just to follow up on that real quick, and I won't take this against the recording. Did the Article 2 powers, the inherent authority of the Commander-in-Chief, give him the ability to take appropriated dollars for the Department of Defense and build a wall?
I can't, without looking at the statute, I really couldn't answer that.
I'm not talking about a statute. I'm talking about the inherent authority of the President as Commander-in-Chief.
That's the kind of question I would go to OLC to answer.
Okay. Get back with us on that. Senator Corn.
Well, Mr. Chairman, let me congratulate you on your election as chairman of the Judiciary Committee and tell you we look forward to working with you and supporting this committee's efforts. Thank you for convening today's hearing. And I want to express my profound and sincere thanks to the nominee, Mr. Barr, for agreeing to serve a second time as Attorney General. I noted in your statement you said it was 27 years ago that you sat in this chair and went through your first confirmation hearing. And to me, that says a lot about your character and your commitment to the rule of law, that you would be willing to go through this process again and serve once again as the chief law enforcement officer of the country.
Thank you for doing that.
Thank you, Senator.
Thank you to your family as well. To me, the Attorney General is one of the most challenging cabinet offices to hold because, as you point out in your opening statement, you are committed to the rule of law and enforcing the laws of the land, but you are also a political appointee of a president. If you are serving another cabinet position, certainly you're committed to implementing the president's agenda or the agenda of an administration, but as Attorney General, that is not an unequivocal commitment, because there may be some things that the administration wants you to do that you cannot do consistent with the rule of law, correct?
That's right, Senator. One of the reasons I ultimately decided that I would accept this position if it was offered to me was because I feel that I'm in a position to be independent. You know, over the years, a lot of people have, some politicians have called me up saying, you know, I'm thinking of going for the Attorney General position in this administration and so forth. And I say, you're crazy. Because if you view yourself as having a political future down the road, don't take the job. Because if you take this job, you have to be ready, you know, to make decisions and spend all your political capital and have no future. Because you have to have that freedom of action. And I feel I'm in a position in life where I can do the right thing and not really care about the consequences, in the sense that I can truly be independent.
Mr. Barr, thinking back about the run-up to the 2016 election, where the nominee of both political parties for President of the United States ended up being investigated by the FBI, can you think of any precedent in American history where that's occurred that you know of?
No, I can't, Senator.
And thinking back to James Comey's press conference of July the 7th, 2016, where he took the step of talking about the evidence against Mrs. Clinton, talking about the legal standard that would apply as to whether she might or might not be indicted for committing a crime under the Espionage Act. Have you ever seen a situation where an FBI director would usurp the authority of the Department of Justice to make that charging decision and hold a press conference and talk about all of the derogatory information that the investigation had gleaned against a potential defendant, and then say, now we're not going to, no reasonable prosecutor would indict her? Have you ever seen anything like that happen before?
No, I've never seen that, and I thought it was a little bit, more than a little bit. It was weird at the time, but my initial reaction to it was, I think Attorney General Lynch had said something, you know, she was under pressure to recuse herself, I think, because of the so-called tarmac meeting. Right. And I think she said something like she was going to defer to the FBI. Mm-hmm. So my initial reaction to that whole thing was, well, she must have agreed, or it must have been the plan, that he was going to make the decision and go out and announce his decision.
Under the normal rules, if the Attorney General has a conflict of interest,
it would go to the deputy.
It would go to the deputy,
correct,
not to the FBI director to make that decision, correct?
Right. So that's why I thought it was very strange. But I think later it became clearer, to the extent there's anything clear about it, that I don't think Attorney General Lynch had essentially delegated that authority to the director. And I think Jim Comey is as I've said, is a extremely gifted man who's served the country with distinction in many roles. But I thought that to the extent he actually announced a decision was wrong. And the other thing is, if you're not going to indict someone, then you don't stand up there and unload negative information about the person. That's not the way the Department of Justice does business.
I was shocked when Mr. Comey later wrote a letter saying that based on the discovery of Clinton emails on the Wiener laptop, that they were reopening the investigation that he had already announced closed. And then finally, just days before the general election, November the 6th, 2016, said we didn't find anything on the laptop that would change my conclusions based on the press conference of July the 6th. Did you likewise find that to be an extraordinary, I will use the word bizarre, but certainly unprecedented event?
Yeah, the whole sequence was very herky-jerky and bizarre, but at that time I was a little of a contrarian in that I basically took the position that once he did what he did in July and said the thing was over, and then found out it wasn't over, he had no choice but to correct the record. So I said that he had no choice but to do what he did, but it sort of shows you what happens when you start disregarding the normal procedures and established practice, is that you sort of dig yourself a deeper and deeper hole.
Why is it that the Department of Justice rules, which also apply to the FBI, make it clear that our chief law enforcement agencies in this country should not get tangled up in election politics? Are there policies in place that try to insulate the investigations and the decisions of the Department of Justice and FBI from getting involved in elections?
Yes, Senator, there are.
And why is that?
Well, obviously because the incumbent party has their hands on the among other reasons, they have their hands on the levers of the law enforcement apparatus of the country, and you don't want it used against the opposing political party. And
that's what happened when the counterintelligence investigation of the Trump campaign began in late July and continued on through, well, presumably to Director Comey's firing and beyond.
Well, I'm not in a position to, make a judgment about it because I don't know what the predicate was for it. I think I said, it's strange to have a counterintelligence investigation of a president, but I'm not, I just don't know what the predicate is, and if I'm confirmed, I assume I'll find out.
Rod Rosenstein's memo recommending the termination of James Comey as FBI director was dated May the 9th, 2017. It's entitled Restoring Public Confidence in the FBI. I take it you've read the memo, and do you agree with its conclusion?
I completely agree with Rod Rosenstein, and I thought the important point he made from my standpoint was not the particular usurpation that occurred, but it was, as I think he says, that Director Comey just didn't recognize that was a mistake, and so it was going to potentially be a continuing problem, that his appreciation of his role vis-a-vis the Attorney General.
As I said, the title of the memo is Restoring Public Confidence in the FBI. Do you agree that restoration of public confidence in the FBI and Department of Justice as a apolitical or non-political law enforcement organization is important?
It's critical
and needed.
It's critical, and that's one of the reasons I'm sitting here. I'd like to help with that process.
Well, Mr. Barr, I think you're uniquely qualified to do that, and I wish you Godspeed.
Thank you, Senator.
It couldn't be more important. Thank you.
Mr. Barr, we've never had a chance to meet, but I welcome you to this committee.
Thank you.